Everyone, I'm Neil Sweeney. Speaking with me in the second half is going to be Chris Cazenave, my partner. We're going to focus on the unexpected and the unwelcome, defective design, which I'm going to cover, and then change conditions that Chris is going to cover. So I'm going to talk about liability for defective design. I'm going to start out with sort of broad strokes of the extreme positions of design build versus design bid build, and pretty quickly after that we're going to go into more practical dynamics of you just tweak a little contract language or just change the circumstances a little bit and the answer flip-flops, where in design bid build the contractor may be responsible for the design, and conversely how in design build the specifics and the circumstances can nonetheless still render the owner liable for design. Okay, so real quickly and simplistically, everybody is probably aware of the Spear and Doctrine. I'm aware of Texas and Longren and the statutory adjustments to that. I'm not going to get into that in detail. I'm going to talk about broad strokes, the rest of the country for the most part, and bring it down to an elemental level, which I know you all know intellectually, academically, but I will tell you people lose track of it, not just on the project, but also in the middle of multi-million-dollar litigation. So let's talk about it. We're talking about design, bid, build, and again, ignoring Longren for a second, it's the implied warranty of the plans and specifications on the part of the owner. Now that's important because the term is warranty. A warranty is a guarantee. It's strict liability. So in terms of the design, the implied warranty of the design, all you need is a defect in the design and damages. Strict liability, the owner's liable. That's it. Now flip to the other side. When the owner is like, wow, I'm paying $1 million, $5 million, $10 million for a defective design, but I didn't design anything. I paid maybe millions of dollars to the designer to design it. So I'm going to go and say, you're going to have to pay the $10 million for that defective design. And the owner is in a completely different situation because virtually every insured professional design project is going to establish liability as a matter of law. The design criteria or the standard, unless changed in the contract, which is tough to do, and then if you do it, you can't get an E&O policy on the contract. Liability is based on professional negligence. The breach of contract standard for a designer is still professional negligence. And the bottom line is where it's a very light burden for a contractor under an implied warranty theory of the design, it's a much heavier burden for the owner going after the designer, because it's not just defect, damages, boom, liability. It's not strict liability. You have to show a defect. You have to establish what the standard of care is. You have to prove that as a matter of fact, that standard of care was violated here. And any of you that have been in this know all of those things can be the subjects of extensive evidence, discovery, expert testimony, and controversy. And then, and only then, is there liability on the part of the designer. And if you think, well, I'm going to jack it up, I'm going to make it a guarantee for them too. Well, good luck with that. You're not going to get an insurance, you're not going to get an E&O policy. That's standard routine, people know about that. So what does that mean? In the middle, in a design bid build situation, the owner is sitting in a liability gap where it could absolutely have liability to the contractor under the implied warranty of the plans and specifications, but it cannot pass through or pass on that liability to the designer, because although there was a defect, the defect did not rise to the level of a breach of the standard of care. And then the owner gets holds the bag. And again, remember, you read any E&O policy, the standard for coverage is what? it's a breach of the professional standard of care. Whether it tracks the language in the contract or not, and typically the E&O underwriters are going to be wary about if the design contract purports to set a higher standard of care, because that completely changes the underwriting and the potential liability there. So same thing, it doesn't matter if the liability gap is not covered if the owner has E&O coverage, because it's the same standard there. And then generally speaking, to the extent there's sub-consultants and things like that, that professional negligence standard passes all the way through. Now, of course, especially when you have, when you're either trying to go after E&O coverage, or in states, it seems like this is where it comes up a lot, where there's a certificate of merit requirement for a claim of professional negligence. Sometimes, and myself and several people in the room here have dealt with situations where the owner goes, no, we're not suing you for professional negligence, we're just alleging negligence. So it doesn't really, we don't have to come up with the certificate of merit, because just for example, in Georgia, if you don't file the certificate of merit with the filing, boom, you're done. You get dismissed with prejudice, you can't fix it. That's not unusual. There are other jurisdictions that have it. And sometimes they're playing cat and mouse, because, well, that's all you talked about was our design. But there are cases that distinguish where that's right. You could sue a designer. They may have liability for negligence, but it can't be with respect to their professional services. And the example is if somebody is wheeling a patient out of a hospital in a wheelchair, and somehow the designer, and usually it's a doctor or a hospital, and they dump the patient out on the curb and they hurt themselves. Well, there's no professional activity going on there. That's simple negligence or maybe an intentional tort. Other thing I'd point out that generally speaking, there's some cases on this specifically. I haven't looked at it lately, but it's consistent with flow-down obligations. Typically, the contractor is going to owe the same implied warranty of plans and specifications to the subcontractors. Now again, there may be some funky circumstances that muddle that pass up liability, and that's kind of some of the stuff we're talking about. And then here, I forgot to put the arrow in, there is, of course, in theory, the potential that the contractor can either come directly at the designer under a professional negligence standard, or the subcontractors could potentially come across. And if you're doing that as opposed to going this way, then you're back to that very heavy burden of establishing professional negligence. Defect, what the standard of care is, whether the standard was met, damages, much more difficult. And what the standard is and whether or not it's been met, again, that's super complicated unless you have a code violation, or something like that where it's almost negligence per se. But I'm pretty sure with enough money at stake, somebody could fight for a long time over whether something was a code violation. So just one of the things I want to emphasize here on this thing, how it is strict liability, two things, because you still see it all the time, I'm sure you do. When the people on the project are writing letters and they're attacking the design, they don't have to say it's malpractice. They don't have to say it's professional negligence. There's two reasons for that. Legally, are you raising your standard of care? No. But as a practical matter, you're setting yourself up to get beat up, to assume, as a practical matter and psychologically, a much higher standard of care. Now again, when you finally get to court, assuming you have a judge that's going to enforce the law properly, that's less of an issue, but during the project, it's very problematic because you're building up that expectation, And so, and you're going to have to carry that at least during the course of the project. The other practical thing is, just think about it. The reason there's a professional negligence standard as opposed to strict liability for designers, just like doctors and lawyers and things like that, we're not supposed to be perfect. Not designers, not lawyers, not doctors, not accountants, any professional service. So we're not supposed to be perfect. And if you come out of the box and accuse the design professional in your correspondence and to the owner that their designer has committed malpractice, one, you've raised the bar that you've got to satisfy psychologically, and two, you've probably pretty much ticked off that designer, as opposed to talking about it just sort of like a different site condition. Stuff happens. It's defect. This is a problem, rather than personally attacking them and besmirching their professional reputation, where they may react a little bit more vigorously than if you just identify a general problem. Just a couple things to think about, further compounding the liability gap that the owner has to cover. You have issues related to limitation of liability, which you're probably going to have to some extent if you're talking about sort of de minimis design fees on some ginormous multi-billion-dollar project. The other thing with some of the very large publicly traded engineering companies now that do a lot of at-risk work, probably less of a concern, but if you're talking about an architectural firm where their main assets are probably rented offices and some computers and their people, they're just going to be thinly capitalized. So if you don't have the insurance, you're going to be in serious trouble unless you want to take their cars and their homes and things like that. And we already talked about how E&O coverage, from a practical standpoint, a financial standpoint, is the major protection. You still have to establish that there was a breach of the professional standard of care in order to trigger coverage in any E&O policy. Now down here, there I got the arrow, but I screwed up its location. Why you generally don't see this is two main reasons. That, for a professional, a third party can assert a tort claim for negligence against them, but a lot of jurisdictions have the economic loss rule that says if it's not personal injury or property damage, you cannot make a claim against someone with whom you don't have a contract. And it varies from state to state. You may get over the economic loss rule if there's just a little damage, like something, an overhang fell down and hit the truck and that the contractor's truck, and maybe that opens up and gets away from the economic loss rule, but it's pretty restrictive. And then, the other theory is third-party beneficiary. Well, go read any design contract. You're going to have express disclaimers in, any standard form design contract, and any design contract where the designer has a fraction of sense. And if there's E&O coverage, there's going to be a sentence that says, there are no intended beneficiaries of this contract. I mean, to just deal with that. And so that's generally going to be blocked. And then just tactically, because of the heavy burden and other stuff, it's really rare that a contractor is going to want to go directly across and after the designer because of the much heavier burden and the sort of fast track on the basis of strict liability. But you may have an owner that's defunct, and that's your only option. So that's in design build. That's who pays for defective design. That's pretty easy. It's pretty clear in theory. Ultimately, the owner pays for defective design in design bid build. It may or may not be able to recover from their designer on the basis of professional negligence, but it's not clear, and it's not an automatic recovery. Far from it. I had a case many years ago at this point, and this is my point about people not just losing track of this on the project site, but in big disputes. Our client got terminated on a very large high-rise hospital in Los Angeles, downtown, And it took us 2 years to get to arbitration because that's how long it took the project to finish. Actually, it was more like 4 years. And on the first day of, the owner brought the architect in. And so we're the CM at risk, the architect and the owner's like, this is great. We're gonna hang back and watch them kill each other. This will be awesome. Well, just in one of the pre-hearing things and the opening of the arbitration, we realized, as the Architects Council realized, that both of us were way more prepared than the owner. And I don't even remember if we ever talked about it, but we had a pretty clear agreement, again, not in writing, that basically if they didn't piss on us, we would not piss on them, which completely threw off the owner because that's what they expected. And in fact, it went so far that we never put on any evidence or made any allegation of professional negligence, what the standard of care was, or anything like that. And this is over the course of 101 days of hearings. But we brought in several subs with pass-through claims, and one of their experts basically opined that it was a breach, they didn't meet the standard of care. So when this point happened in the hearing that I'll tell you about, we stood up and we're like, well, he was incompetent. He was not qualified to say that. So there's no evidence of professional malpractice. And so what happened after the owner rested their case, the attorney for the architect stood up and said, we move for directed verdict, whatever, summary relief from the arbitrators. We shouldn't have to put on defense because there's no evidence of malpractice against us. And we let the architect argue, but we were like, nope, we have no evidence, and that guy was an idiot. You can't rely on his testimony. And the attorney for the hospital, and it was a big law firm, and it was a good lawyer, not a construction lawyer. And he basically said to the panel, like, oh, what are you, crazy? Are you telling me I could be liable for defective design to the contractor, but I can't pass that through to the designer? Like, that's the craziest thing I ever heard. And like all three of the arbitrators were like, yeah, that's pretty much, that's right. Yeah, you have a problem. So they did get thrown out. But again, all this is in theory. You don't deal in theory. Anybody in the positions you're in, and especially the lawyers, if it's something that's brought to your attention, it's in a gray area. It's not black and white. And that's really what we're going to focus on here for a while, and then with respect to flipping to design build. And this relates to the 5 most important things in any construction claim. Have you all heard this before? Learned it from my mentor and senior partner, long gone, Overton Curry. And it's I just remember him saying that at seminars, and after a couple of years, I'm like, oh my God, that's exactly right. The 5 most important things are the law, the facts, the facts, the facts, and the facts. The law is literally the easiest part. The hard part is how on a construction project, whether it's $1 billion project, a $5 million project, a $50 million project, all the variable circumstances and interactions that happen out there, and you just tweak those facts a little bit, add some, deduct some, could completely change the result. Couple things about the implied warranty. First of all, I always warn people about this. Everything related to construction, be aware of the difference between federal law and state law. Because most people, when they talk about black letter law, including myself, when it comes down to it, they're generally speaking about federal government contracts construction law, unless it's like Texas construction law or Arizona. And I challenge you to look at the footnotes. If you have a paper or an article that are describing black letter law, you will see that the majority of citations are federal law, which is not controlling in basically any private dispute. So you always have to check the state law. And in a book I've edited for over 30 years, I've had 2 chapters, one about 20 years ago and one about 8 years ago, where it looks specifically at Great, everybody knows the Spearman Doctrine, that's federal law. How has that really been adopted and applied on the state and local level? And it's more consistent now, but it's still not always consistent, and a lot of states just haven't ever answered the question. Of course, you have Texas, which since 1907 under Longren has been an exception, and that's only been addressed to a certain extent recently by statutes. So again, that implied warranty only applies to design specifications. It does not apply to performance specs, which we're going to talk a little bit more, or generally it doesn't apply to design build, but we'll talk about where maybe the implied warranty doesn't apply, but the circumstances and the terms of the contract, or even the terms of the request for proposals, nonetheless make the owner liable. Another little thing to look out for, whether it's in a contract, a construction contract, or in a subcontract, is there anything that tweaks the implied warranty? Because most implied obligations under a contract can be waived. Generally, there's not that much success in doing it, but still, what if instead of, your obligation is to, as the contractor or a subcontractor, to identify any defects that you're aware of, but you just add a little bit of, you add a couple words that says that you discovered or should have discovered. So then at that point you get into a factual argument. And you could have one factual argument about patent latent, and if you know about it and it could be proved, boom, you got to raise the issue. You can't lay behind the log, you can't sandbag, and then come out and complain about the defect later and try to take advantage of it. You could fight over that. But if you throw in there or should have discovered, that just opens up potentially a lot more liability and at least a Pandora's box in terms of fighting about it. And then the other thing, in terms of construction management at risk, that's been something that I've fought about from California to Miami, and I can't remember where the other place was. Oh, Boise, where projects went off the rails, construction manager at risk, the owner comes after the contractor, the CM at risk, and goes, wait a minute, we remember that great presentation you did where you said you're going to be involved in the design development, you're going to provide scheduling discipline, you're going to do a constructability analysis and look at all this stuff. So when the bottom drops out in the project and there's just bad things happening, and especially if it's related to design, you got a good chance that the owner is going to say, you know what? You're responsible for this, construction manager, because you said, and we paid you extra to review the design to address constructability. And again, I realize that's different than a professional designer designing the project. And I mean, that's just a routine thing that's happened. I already explained to you, and that was one of the basic things in that Los Angeles arbitration I talked about. On the Miami Performing Arts Center about 20 years ago, same argument. They just said, they're like, yeah, basically the steel design was not coordinated with the utilities and nothing fit, and even the interior, it was all goofy. And the owner's like, that's your problem. That is not our problem. I'll talk about how that was solved. And then another case I had was for the expansion of a detention facility in Boise, Idaho. And in that case, we had a jury trial. And we have, and there are all these arguments why that's baloney. You paid a de minimis fee, you didn't do this. But when you look at the language of a lot of CM agreements, you could see, I thought there was a real risk that it was going to get to the jury. And then we could have been toast. We ended up settling, so we never got there. But that was a high motivation. In the last couple of years, there's a case, I think it's in Massachusetts or something, that said it doesn't, that basically on summary judgment says that doesn't apply. Okay, I gotta go through much more quickly than I planned. Again, performance specs, those are design build responsibility there, especially window walls, stuff like that. Shop drawings, you change the design and you don't flag it under the AIA, even if it's approved, then that's your baby. That is your design. And of course, there's a secondary design review where it's the fill in the gap stuff, which again is another great thing to argue about. They didn't show control wiring, control piping. Is that in the project or not? Most of the time you're gonna say yes, because that's a fill in the gap thing. You get into other variables about that. Now we're gonna go to the other extreme. Who pays for defective design and design build? And pretty much there, it is one-stop liability. It's generally the design builder is gonna pay for defective design, regardless of the structure of the agreement, unless other things happened. And I won't be able to go through all these slides. There's other slides that you'll get that talk about specific cases that demonstrate how in design build, the owner was still liable for elements of the design. So the terms of the contract are gonna apply. Potentially the owner's technical expertise and level of involvement in the design is gonna potentially have an impact on the determination. Limitations imposed on the design. It's like you're the design builder, but this has to be this way. It's almost like a combination of performance specs and design specs where they don't fit together and it creates a conflict. Partial design, same thing. Information provided and failure to disclose information. Again, the terms of the contract and the solicitation. I'm just gonna go to, if you look at the slides, when you get them, you'll see there's all these circumstances where one classic one is where it's a big retrofit of a Navy laboratory and the building was occupied and the design builder went in. It was limited access. All they could do was get on a stepladder and pop up the drop ceiling and look around, and it was required a complete structural retrofit. So they priced it according to what they perceived, and then once they did the demo, they realized, whoa, what we had in the as-built is not accurate. The structure, the steel, everything is well undersized, and we've got to beef up the steel and the concrete. And a lot of your design build cases are federal cases. Let me make that clear too. So these are all just illustrations. They're not just binding in your jurisdiction. And the contractor pointed out, oh, the owner's position was, hey, it's design build, you have to be liable. That's it. And the contractor came back and relied on differing site condition and failure to disclose. And you look at most design build contracts, they're gonna have standard differing site condition clauses. And in this case, the Board of Contract Appeals found like their site inspection was reasonable. They could not get into the ceiling and see anything. The facility was operating, number one. Number two, the damning thing was somewhere in the bowels of the government, there was information that demonstrated that the government knew the structure was undersized. And I don't know if they intentionally didn't disclose that or, it just was sort of like the warehouse at the end of Raiders of the Lost Ark. But in any event, the court said, well, number one, it was a reasonable site inspection. And the other thing, and they said it was both kinds of differing site conditions. And then they said, in any event, that is failure to disclose information. So the design build does not dictate anything. And conversely, some other cases that are in the slides later talk about situations where there were design spec elements in the design build contract, and the court, and there's several cases like that where the court's like, no, just because you're a design builder, it doesn't mean you're allowed to blow off anything that's specifically called for. Like one is there's a bunch of fans and pumps and things that was in the partial design that was given that was part of the scope, and they're like, well, we thought we could take that out, or we thought we could run this different conduit. And pretty much when they get to the facts, and contractually they are design specs, or specific requirements of the owner, just saying, well, I'm the design builder, I can do anything I want, that does not work either. And, well, the design builder is liable for any extras or problems with the design that they accepted.
So Neil actually left off at a good point that I'll start off on, which is, defective specifications has often a lot of overlap with the topic that I'm going to discuss today, which is different site conditions. Neil also mentioned what was called the superior knowledge doctrine, that the government knew something that they didn't disclose. These are, one of the things that maybe the most important thing to cover today is approaching different site condition claims, which are eyes wide open, meaning I think everybody here is familiar with a type 1 claim, a type 2 claim, whether or not it's in the contract, whether or not it's reasonably foreseeable at the site. But you don't need to box yourself in there. It could have elements of defective specification. It could have elements of superior knowledge. It could have elements of mutual mistake, misrepresentation, fraud in some circumstances. So with the same set of facts, but different elements of proof, you can be successful. I'll go over a case Neil and I had to illustrate sort of how many different theories of relief you can bring in connection with a different site claim. And then we'll close out with some practical suggestions for owners and contractors. So I have to admit, I stole this quote from Rich Tyler back there, but I think it fits the situation pretty well. So only the unknown frightens men, but once a man has faced the unknown, that terror becomes the known. What's the trade-off here between the owner and the contractor? Why do we have these provisions? To allow contractors to submit more accurate bids, to not price contingencies that might not exist. On the other foot, the owner's conundrum that, facing inflated bids for possible but non-existent contingencies versus the limited exposure for risk that the contractor is in the best position to determine. At least in my experience, and I'm sure my colleagues would agree, different site condition claims remain very common. And they can be one of the most difficult claims for a contractor to prove. So this was what I mentioned out at the opening, where does my claim fall? Well, is it a type 1 claim, type 2? Is it the superior knowledge doctrine? Is it defective specification? Something else, all of the above. The point is that depending on, the superior knowledge doctrine, for example, doesn't require notice. Well, suppose you didn't provide notice that you needed to provide in accordance with the contract, and the court finds the failure to provide notice was that's fatal to your different site condition claim. Well, you got to find another shoe that fits. This is a project Neil and I worked on. It's like 2.4 miles of excavation and reconstruction of a levee. This green line is the Santa Ana River in Southern California, and the purpose of the levee was to keep the water out of those people's homes and businesses. And so we, one of the large claims in the case was our claim that there was a different site condition due to continuous clay lenses. So if you can see here, these clay layers cause water, right, to perch on top of them, and the water keeps draining into the excavation, and then it rains and it recharges and back into the excavation, and makes it tough to get the job done. So, for a type 1 claim, obviously we said the presence of continuous clay lenses was not reflected in the contract documents at the particular stations that we were digging. But in reality, the contract documents did indicate that we would probably encounter clay at some magnitude. It was going to be a tough road. Type 2, even tougher, right? That we couldn't reasonably expect clay to be at this site. Well, it's a riverbed. So we had real problems with that one, right? But we keep going. Superior knowledge, we knew that this was just one project of many projects along this stretch, and we wanted to see whether or not the government had disclosed in the solicitation that clay was going to be an issue, whether or not they were aware that other contractors were in fact having problems with continuous clay lenses. And ultimately, we didn't find that. But and a defective spec, I'll skip that one. But ultimately, well, let me go back. Ultimately, in this case, I took one of the engineer's depositions who was not aware of this claim, and he conveniently testified for me, his lawyer's mouth dropped, that we were terminated for default. The replacement contractor, they immediately allowed this replacement contractor to relocate the excavation in this area because the clay was so thick. So that breathed some life back into this claim. The case ultimately settled, but again, the point is the claim wasn't dead in the water because we kept on finding a way to keep it alive. Because it did, in fact, cost us a lot of money. I mean, we had to install a whole new well system, and it was a mess. I'll cover a few cases to try to illustrate the overlap between different site conditions and, in this case, the superior knowledge doctrine and how courts treat it. So Marine Industries, this first case, that was a maintenance contract for dredging on a river in Washington State. The court terminated the contractor for default. The contractor appealed the termination and sought additional compensation and time for different site conditions and the superior knowledge doctrine. There was a lengthy opinion, lots of issues, but what I'll review here again is the court's analysis of the DSC claim versus the superior knowledge claim. So the plaintiff's different site condition claim, type 1 claim, failed. It was again in the presence of clay, and the court found that the contract documents unequivocally disclosed that there was clay, in this riverbed. They didn't even try for a type 2 claim. But what the plaintiff was successful on is the claim that the government had withheld knowledge that debris was present and that it caused delay. And they were able to simply do so by going to other projects in this area where the solicitation contained an express warning from the government that there was debris. Well, it was removed from the solicitation, and inexplicably so. And so the court ultimately, found that was sufficient to satisfy the superior knowledge doctrine, and they were able to recover on a claim that otherwise would not have been recoverable, at least under a different site condition theory. Notice, so Marine Industries, same case, under FAR and other clauses that I'll skip to in a minute, the contractor must provide notice before the area is disturbed, and it must do so promptly. Well, here, Marine Industries took 46 days from first encountering the condition to reporting the condition. And the court said that was, standing alone, that was fatal to their different site condition claim. Here, they found that the government waived the requirement, but the point is, and again, they were successful with the superior knowledge doctrine. But, and the point here with my second set of bullets is, so if you didn't provide notice, right, you got to look to other theories. And these other theories don't have a notice requirement. So jump back, I think there was a case on an earlier slide, North American Landscape, and it was a dredging contract with the Corps for a creek in Virginia. And the court here analyzed a site inspection clause and found that basically the site inspection clause created a duty for this contractor to conduct a site inspection, and in here it was to determine the amount of barge traffic that was going to interfere with this project, which was on the river. And this is in, so I won't read this, but here for a site investigation clause, this is an example from the FAR. You're acknowledging that you satisfied yourself as to the existing conditions on the site, so it's no excuse that that you find something that you should have found because you had an obligation to do so. Same is true of these geotechnical information disclaimers, right? it's basically saying we're giving you information, but we're not responsible for what you do with it. And you're not going to turn around and make a claim based on the data we provided about site conditions. So here we just covered different site conditions versus superior knowledge. Well, and Neil had covered defective specification. So here is a case where the court is considering the difference between different site condition versus defective specifications. The Nova Group case, it was a Navy issued a solicitation to build a pier in Washington State, and solicitation included a geotech report that had two things in it. One, it had the soil conditions at the site, and two, it recommended what piles could be used to reach the depth that was necessary to ensure stability of the substructure and whatnot. So construction begins, and the contractor cannot drive the piles as he expected. And so Nova Group brought a claim, 3 theories, right? Type 1 DSC, Type 2 DSC, and a defective specification. And the Type 1 claim failed. Court found that the report, the geotech report indicated that these conditions, this dense soil that impacted the pile driving could be found at the site in some magnitude. Type 2 claim failed. Court found that they could have expected boulders and dense soil in this area. And here, the defective spec claim failed also. And it's because there's precedent in the Federal Circuit, basically, that although a different site claim and a defective specification claim are different animals with different elements, the claims collapse into one if the claims are so intertwined, as the court found here, basically that the different site condition was the predicate for any claim about defective specifications. I mean, the court basically said the defective spec claim was just recasting the different site condition claim, and here they were seeking the same amount of damages, so it didn't fail. So don't worry, I'm not going to read all the clauses in these various industry forms, but I'm going to point out a few differences that you might consider when you are drafting a contract and trying to pull together your different site condition clause. So I say they're not all created equal, but they are all pretty close. And the AGC and the EJCDC put burden and notice squarely on the contractor. AIA, puts burden on the observant party, which I found different. Use AIA, we think owner friendly. Why wouldn't it just leave it to the contractor? But in any event, the AIA puts the burden on the observant party. The FAR and EJCDC require prompt notice after observance of a different site condition. The AIA goes further. It defines prompt as 21 days. The EJCDC, perhaps not surprising, drafted by engineers. It's more detailed about the subsurface and physical conditions versus underground structures, and it's also more detailed about what kind of data, technical data or non-technical data, can be relied upon to determine whether or not there's a different site condition. But this last note, basically, the DSC provisions are all born, at least from the AIA, AGC, and EJCDC, out of the FAR clause. So again, they are pretty similar. So you're struggling with the risk of different site conditions. So here I'm gonna cover some practical suggestions for owners. First, disclose all known conditions prior to submission of the bid. It's consistent with this goal that you want accurate pricing in the first place. You want the contractor to price contingencies that you're aware of. Second, you are creating a superior knowledge claim if you know something that you're not disclosing. For the owner, strict notice requirements make sense. To define it maybe like the AIA and use 21 days rather than prompt, to allow no room for error as to what constitutes sufficient notice. Another thing I see is that an owner tries to limit the recoverable cost to only direct job site costs incurred, so no home office overhead, no indirects, just the cost that are associated with the different site condition. So even if you have these exculpatory clauses that I mentioned earlier, whether it's a geotechnical disclaimer or a site inspection clause, you may still not avoid liability if you are making positive representations in the contract of what the site or subsurface conditions are. So you just need to be cognizant of, are you making positive representations about the subsurface? And if so, how many are you making? Where do they appear? Is it not just because we're not just looking at the contract here, we're looking at any geotechnical reports or anything else that might make up the contract documents. And then obvious maybe, but you should be certain before letting the contract to know how the contract allocates the risk of both unknown and different site conditions. So for the contractors, again, first, carefully review contract documents. And again, it's not just the contract. We're all aware of that. It's everything that's in the solicitation. And make sure you understand the risk allocation between you and the owner. I would look for onerous exculpatory clauses and disclaimers about geotechnical data being provided. Go see the site, what's around it, and determine whether or not more geotechnical work was needed before you bid the job. The case that I alluded to earlier that Neil and I had, that was one of the Corps' principal defenses, is that you could have came out, you could have took more boring logs, you could have potholed here, you could have did all these things to determine what kind of machine you needed and what kind of methodology you needed to use, throughout that 2.4 mile stretch. Understand the law in your jurisdiction. Sometimes it's the cases are significant as to the allocation of different site condition risk, whether or not more owner-friendly or more contractor-friendly. So kind of to sum up, to try and avoid some of the pitfalls when encountering a different site condition, and this is from just the contractor's perspective, but basically provide notice. Failure to do so could bar an otherwise valid claim. Document, and in this instance, when we're talking about a different site condition, that's more than meeting minutes and daily reports. That means videos, photos, surveying, any other information that can be collected contemporaneously to later on support your claim. Consider employing a geotechnical expert before the conditions are disturbed. It'll help you down the road with entitlement and quantum, and could help you right then and there to determine whether or not, well, one, how you can deal with the issue, and two, sort of armed with the technical information that early on to have the discussion with the owner about, why you believe it's a different site condition. It's tough, as many of you have been involved in litigation. Doing this 3 and 4 years after the project has happened is much more difficult than doing it in real time. And then the last thing is get help, from your in-house lawyer, your outside counsel, that geotechnical expert, and help to develop a plan to put you in the best possible position, in light of different site condition risk.